Section Business Litigation Committee Case Law and Legislative Update. My name is Allison Leonard. I'm a lawyer at Damien and Valori Como Trial Attorneys in Miami, Florida. We are a business litigation and personal injury law firm. I currently serve as the vice chair of the Business Litigation Committee of the Business Law Section. Before we begin, I'd like to recognize our committee's judicial chairs, Judge Edward LaRose and Judge Darren Gales, our committee chair, Giacomo Bosa, and vice chair, Paige Greenlee, and also the members of the CLE committee who helped organize this CLE series, Amanda Fernandez, Alejandra Iglesias, Peter Klock, and Russell Landy. So we've put together a three-part case law and legislative update for you all. All three parts are complimentary and they will be posted on the section webpage as well as our YouTube page, along with any associated written materials if there are any. Last Wednesday, we hosted part one of the series. Manny Farach presented a real property and business litigation update, and Doug Bell presented a comprehensive overview of the of our state legislature, the legislative process, and our section legislative priorities, as well as what we can expect this coming legislative session, starting early next year. On November 12th, we will present part three, also at noon time, part three of our series, which will cover case law updates for bankruptcy, UCC, and corporation securities and financial services. I said already that all three parts will be complimentary. They're posted on our section website. Today, we have an exciting presentation prepared for you. We have Peter Mascow, who will be presenting the Computer and Technology Law Update. Peter is the current chair of the Business Law Section's Computer and Technology Law Committee and a litigator based out of McGlinchey Stafford's Fort Lauderdale office. And then we will have Jim Matalis, who will be presenting the Intellectual Property Case Law Update. Jim is board certified in intellectual property, and he is the current chair of the Business Law Section's Intellectual Property Committee. He is a litigator and also serves as a mediator in all types of intellectual property disputes throughout the state, both in person and by Zoom. A couple of housekeeping matters before we begin. This is set up as a webinar by our section administrator, the fabulous Stephanie Svisco, who is here. And that means that only the presenters have the capability to speak and be viewed on the video. So if you're watching this and you can't see yourself or speak, that's on purpose. If you do have a question during the presentation, please go ahead and use the Q&A function at the very bottom of your Zoom screen. It should say Q&A and have two little speech bubbles. Click on that, you'll be able to type your question right into the box. And at the end of the presentations, if time permits, I will read those questions out to our presenters so that they will have an opportunity to answer them. The course number for this CLE is 4232. It has been approved for one general credit and one business litigation board certification credit. With that, I will turn it over to Peter to go ahead and get us started.
Thanks so much, Allison. So I'm going to go ahead and share my screen here to get the presentation going. And as Allison said, my name is Pete Mascow. I'm a litigator in Fort Lauderdale, and I'm also the chair of the Computer and Technology Law Committee of the Business Law Section. So the first thing I wanted to just quickly address is, why is computer and technology law important, especially to a business litigator? Well, a theme of this area of the law is the notion of how existing law, whether that means case law, statutes, or regulations, is being applied in light of the effect of new technologies. Sometimes this can result in imperfect or strained applications of law that was conceived prior to the inception of those technologies. And here I've got a quote, and it actually came from the Supreme Court nomination hearings last week, and it was Senator Tom Tillis. And in relevant part, he mentioned that a witness before his committee said that they've got MySpace laws in a TikTok world. And the witness was actually Don Henley of the Eagles, and he was testifying on behalf of the Digital Millennium Copyright Act. But I think it's relevant here just to illustrate that point, that the laws sometimes even outdate MySpace, and it takes some interesting legal analysis to apply how new technologies impact those laws. And it's also important to consider not only how courts are deciding cases on those older principles, but to consider what implications decisions on technology we have today will have on technology we have in the future as it continues to evolve. We're seeing in the legislature bills like on data privacy and biometric security being introduced in recent years. We anticipate to see those continue to arise, and that's something to keep an eye on going forward as well. First case I wanted to briefly touch on is something else that happened last week, and it was a denial of writ of certiorari by the Supreme Court, and Justice Thomas issued a statement respecting the denial. The Malwarebytes versus Enigma case is something came up from the Ninth Circuit. The Ninth had previously recognized that the so-called Good Samaritan provision of Section 230C2, which is a provision that immunizes software providers from liability actions taken to help users block certain types of unwanted online material, establishes a subjective standard where internet users and software providers decide what online material is objectionable. Both parties here were software providers, and Malwarebytes essentially used its filtration software to block Enigma's content, and Enigma claimed that that was because of an anti-competitive bias. Malwarebytes countered that it had separate reasons for blocking it other than competition, but the Ninth Circuit concluded that allegations of anti-competitive animus was enough to withstand dismissal under the immunity. And so what Justice Thomas said when the Supreme Court rejected cert was he noted that Section 230 gives the internet platforms immunity from civil and criminal claims, and that when it was enacted, many of the internet platforms we have today didn't exist. He said that paring back that sweeping immunity that has been read into Section 230 would not necessarily render defendants liable for online misconduct. It would simply give plaintiffs a chance to raise their claims in the first place. And I think this is especially interesting given the news we've had this week about the manner in which Facebook and Twitter are alleged to have blocked certain content from being circulated on their platforms. So this is an issue nationally that's getting some attention now, and I think it is a good illustration of how when this law was enacted, the type of online forums that we have today just weren't anticipated, and now it's something that we have to deal with. So turning a bit closer to home, first case from Florida, Doe v. Nat came out of the second DCA a little bit earlier this year. Some background on this case, it's a Texas couple was vacationing or wanted to vacation in Longboat Key. They used Airbnb to rent a condominium unit online for a short-term 3-day rental. They used Airbnb's website to make the booking. Stay occurred in May of 2016. And the condominium unit was owned by a man called Wayne Nat. And the allegations of the complaint say that unbeknownst to the Does, the plaintiffs, Mr. Nat had installed hidden cameras throughout his unit. And they alleged that Mr. Nat secretly recorded their entire stay, including some private interactions that they had had. They also named Airbnb as a defendant, and Airbnb sought to compel arbitration through an arbitration clause in their online agreement. And so this brought the court to consider what it classified as a rather arcane issue of who decides whether a dispute is subject to a contract's arbitration provision, an arbitrator or a judge. And the court looked at the agreement and said that this is a click-wrap agreement. And a click-wrap agreement has been defined as one that has been entered into by proposing contractual terms and conditions of service to a user, who then indicates his or her assent to the terms and conditions by clicking in I agree box. So you're actually prompted, you click I agree. I know many of us do this numerous times a day. It's important because it's distinct from a browse wrap agreement where the terms and conditions are located in a link somewhere on the website. Here you're actually manifesting your assent to the terms of the agreement. Also, the standard here to have an arbitrator decide arbitrability is that the agreement must be by clear and unmistakable evidence. So here, the agreement did not quote or specify any provision of the rule, and it didn't specifically say arbitrability is to be decided by the arbiter. And the court noted that the AAA rules were not attached to the agreement. In the original opinion, it characterized it a little bit differently and said, it does not appear from our record that an operative link to the AAA rules was even provided with the online click-wrap agreement. And that's interesting because it questions whether or not a link in and of itself would have been sufficient to satisfy the clear and manifest evidence required to compel it to arbitration. In the original opinion, they said it wasn't, but they've tried to leave it out of the opinion on rehearing. Another sort of further source of confusion here was that the rules had actually changed enumeration during the interim, and there was some discussion about one of the links in the agreement that was contained actually being broken. And so that kind of calls into question, even if there was a link, we'd have to look at when that link was active, what it linked to, and so just further issues that going forward would be worth considering and parsing out. Here, the second said that the agreement just directed the does to the American Arbitration Association's website and phone number, and they actually had to go digging through the AAA rules, and they saw that as an obscure way of evincing a clear and unmistakable evidence that they would preclude the court from deciding whether or not the dispute in this case was arbitrable. They continued that in this case, it was a conferral of adjudicative power to an arbitrator found within the body of rules that were neither attached nor linked. So they didn't completely purge links from the opinion to the agreement, and that agreement in itself did nothing more than identify the applicable body of rules. And they questioned that whether or not that would be clear and unmistakable evidence. They concluded that a contract's arbitration provisions reference to the arbitration rule alone that does grant an arbitrator authority to decide arbitrability does not clearly and mistakably supplant a court's power to rule on the issue of arbitrability. There was a dissent filed by Judge Volanti, and he pointed out, again, this issue: when paper is eliminated in favor of speed and convenience, it should come as no surprise that parties resort to incorporating material by reference, which in this instance includes the AAA rules, and specifically Rule 14A, which allows the arbitrator to decide arbitrability in the first instance. Like I said before, the original opinion had a little bit more discussion of a click-wrap agreement and whether or not it was linked in the majority opinion, and so there was some additional discussion in the dissent. A secondary issue here was whether the rules themselves gave a mandatory delegation of power, but it'd be interesting to see in a future case if there's appropriate links within the agreement itself, how that would come out. And this case itself, to be continued, its conflict was certified. It's up on the Florida Supreme Court now. The jurisdictional briefing is pending, and so we'll see if the Supreme Court gives us an answer to some of these issues, or if it agrees with the second district. Next case comes out of the third district, Megacenter US LLC versus Goodman Durell 88th Court LLC. This is a case that has to do with compliance with conditions precedent. And the particular agreement in question here had a notice provision that said any notices required or permitted to be given under the agreement should be in writing and shall be deemed to have given if delivered by registered or certified mail, hand delivery, overnight courier, or facsimile with confirmed receipt. It also had provided for copies to be transmitted to the parties and their counsel via email. What actually happened was an email went out from one party to the counsel of the other, and the other party's counsel sent an email back acknowledging in receipt, said they'd take a look at it. Ultimately, the contract got terminated. And so the court, in considering whether or not that email was sufficient compliance with the condition precedent, first observed that strict compliance with the notice position isn't required if there's actual notice to one of the parties, and instead substantial compliance would only be required in that instance. Here they said that the record is clear that Goodman's counsel received Megacenter's timely email written notice of termination, and that the party cannot claim it never received notice where it accepted the email, sent back a reply, and had actual notice of their termination. So what I thought was interesting is considering some of the different technologies we have for communications, would something akin to a read receipt, like the picture I have here, be sufficient to provide notice of receipt? And then maybe extrapolating a bit further, what if the notice went through a text message or iMessage? Would a read receipt be enough? Or what about someone that has read receipts turned off on their phone and it just tells us that it was delivered? Is that going to be enough to show that that notice was received and accepted? Or finally, what about using shared files on Google Drive, Microsoft Teams, or Slack that so many people collaborate on today? Would notice through any of those forums be sufficient? And I think it's going to turn not only on whether or not notice was received and accepted, but was there prejudice in giving notice through that form? And was that forum one that the parties communicated regularly such that the notice would sufficiently apprise them of notice? So going forward, just different ways people communicate today don't always fit with contracts that are in place. And it's interesting to consider how these new technologies are going to impact these issues going forward. The next case is a case arises out of the foreclosure, and it's one that deals with the admission of computer business records into evidence. Here, the Supreme Court said that testimony of years of experience with the bank and familiarity with the company's business practices was enough. That was direct evidence with relevant business practices and was sufficient to show that the witness is qualified to introduce the computer records testimony, authenticate the documents, screenshots that came from those computer records, and laying their foundation for admission. There was a dissent. It was authored by Justice Polson. Justice Labarga concurred in it. And they said that when the business records sought to be admitted are in the form of computer or electronic records, such as a computerized loan transactions history here, they'd want to see the witness lay foundational testimony about the record keeping itself, their familiarity with how that record system works, and their use and access of that system before having found the business records exception satisfied. So a little bit of an interesting disagreement there. Certainly an issue that recurs all the time, not only in foreclosure cases, but in cases generally. Next, law offices of Hersign and Hersign PA versus USAA. And this case dealt with whether a judge who was a Facebook friend with an attorney had to recuse themselves from the suit. And the specific issue that the Supreme Court answered was whether a reasonably prudent person would fear that he or she could not get a fair and impartial trial because the judge is the Facebook friend with a lawyer who represents a potential witness and party to the lawsuits. To answer the question, the court looked at the differences between friendships in real life and friends on Facebook. And one of the things they pointed out was in many rural communities, judges and attorneys are friends in real life. And they have an ongoing friendship relationship. And then they examined, well, what's the nature of a friendship and relationship, setting aside whether or not friendship in real life would be disqualifying. And the court said a Facebook friend may or may not be a friend in the traditional sense of the word. But Facebook friendship is not, as a categorical matter, the functional equivalent of a traditional friendship. The court continued, though, that the mere existence of a Facebook friendship between a judge and an attorney appearing before the judge without more does not reasonably convey to others the impression of an inherently close or intimate relationship. Now, Justice Labarga wrote a concurrence, and he cautioned judges and strongly urged them not to participate in Facebook at all. And he said for newly elected or appointed judges with existing Facebook accounts, he encourages their deactivation of those accounts altogether. Now, he noted that many people use Facebook to keep in touch with old friends and family, and he recognized that judges do it just as well, and recommended to those judges, if they do so, to be especially careful about who they have as a Facebook friend and to use their privacy settings to ensure that the accounts are as private as possible so that it doesn't convey the sense of impartiality. There was a dissent as well. Justice Pariente wrote it. Justices Lewis and Quince concurred. And their opinion was that judges are not like the general public and other elected officials that have Facebook accounts. but they take on a responsibility when they become judges. They put on their black robes, and they have to limit activity that they may have had before they became judges. One of those was social media to communicate either actively or passively with attorneys that appear before them. And this is because of the importance of fairness and impartiality in the judicial system. One question that this might raise is the use of Facebook for a judge that's running for an election. Facebook, as we've seen, is an important tool in voter outreach and connecting with people and getting them to turn out to vote. Looking at some of the judges coming up for election in the current cycle, it appears that the way that they've been handling this is they create a political candidate page rather than having a personal Facebook page. And most of them have removed their Facebook pages altogether. And the political candidate page can be liked or followed instead of being friended. And that creates some further distance between friendship and Facebook being a forum to connect with people. And that's probably a more proper use of social media. So next is Arco Plumbing versus Rudd. And this is a case out of the 3rd District. It's a little bit older, from 2017, but what's going on was Arco Plumbing was a company that provided homeowners with what the court called a video colonoscopy of cast iron drain pipes to locate cracks in the damaged pipes. There was an insurance claim related to those cracks. The attorney, Rudd, represented the insurance company in connection with their denial. He used a former Arco Plumbing employee and got their still active password. He accessed Arco's called Motomon Global Positioning System account, found a historical location of the service vans for the company. And then he went and subpoenaed the plumbing company for that information, including related to service vans at the homeowner's residence in connection. He got sued in a complaint. When it was amended, those included counts of civil conspiracy, deceptive unfair trade practices, theft of trade secrets, and the like. And the court granted summary judgment in favor of the attorney based on the litigation privilege, saying that the actions were taken in connection with the prior insurance claim litigation, and so he was provided immunity. The 3rd DCA reversed that and said that Rudd was accessing the account on his law firm computer, and that was a non-commutative act, similar to sneaking into an old friend's house to look for books in his library. It doesn't communicating with a friend, using someone else's password to get the account information. It doesn't communicating to another person. And without a communicative act, the actions fall outside the protections of the litigation privilege. And so therefore they concluded that sitting at your own computer, accessing someone else's account through a password that's not your own was a communication not subject to the privilege. Next case is Lugari Markets versus state. And the background here is it was a state division of alcoholic beverages and tobacco had issued a statement that sale of alcohol through automated dispensing machines violated Florida beverage law. Lugari Markets, they operate cafes in residential buildings and office buildings, and they're completely automated. So someone can come in, get what they need, do a self-checkout, and there's no clerk there to complete the transaction. In order to buy alcohol through the machines that they had proposed, the residents would have to use biometric data, like a fingerprint, to confirm it was them, and that account would be linked to having previously shown proof of their age. And once that was confirmed through the system, it would complete a purchase through the automated dispensing machine. 2 of the statutes the state challenged them on were section 561.702, which has the intent of the legislator to eliminate alcohol sales to underage people, and section 562.11, which makes the sale to underage persons a second-degree misdemeanor. What the first DCA said was nothing in either statute addresses whether sales of alcohol require face-to-face transactions or prohibit sales through ATMs. And so use of biometric identifying data to confirm that a person is over the age of 21 and able to buy alcohol wasn't something that the state could ban through the opinion that it had issued. Next, State versus Espinosa, it's a third DCA opinion, and it considered Bitcoin. And essentially, someone online had offered to meet another person at an on-site location, cafe, and to exchange cash for the Bitcoins. And the court considered whether or not an individual exchanging Bitcoins for cash like this was a money services business, as defined in the Florida statutes. And as a money services business, required the person conducting the transaction to register as a money transmitter under Florida law. Here the court had said that there is no plausible interpretation of monetary value or payment instruments, as those are defined by Florida statutes, that place Bitcoins outside of the statute's ambit. It's notable that the decision here contradicted with some prior regulatory guidance on automated Bitcoin transfer machines, sort of like ATMs, where they said that there wasn't a need to register because of the absence of a third party. That's really the guidance that we've got from the third DCA, though, contradicting that opinion. And so it's interesting to see if this becomes an issue that develops more going forward. Turning quickly to a couple of federal court cases, Lewis versus Mercedes-Benz USA, it's notable because the court found sufficient compliance with European data privacy law to serve as evidence of an undue burden in complying with discovery requests. The court said that the defendants had specifically identified the unreasonable discovery burdens they would face. And given that 2 of the 3 are foreign entities, they're going to run into the European data privacy laws, as they're based in Germany, along with other foreign rules and regulations, and the unduly burdensome nature of compliance merited them not making that discovery in this case. So if you've got clients that are subject to European data privacy laws, or you're facing one, unreasonable burden might come into play with compliance. Another case, Brown versus Vivint Solar Inc. The court opined on when computer-generated business records are admissible under the federal rules. And there they said the records must be kept pursuant to some routine procedure designed to assure their accuracy. They created must be created for motives that would tend to assure accuracy, and they must themselves not be an accumulation of hearsay or uninformed opinion. So it's a little bit distinct from the ruling we got in Florida, and it tends to look a little bit more at the computer system itself than whether or not the employee was employed long enough by the company to admit those records into evidence. Lastly, just a couple criminalish cases worth mentioning. Garcia versus State came out of the 5th DCA just in August. This is a case where the police were trying to force the criminal defendant to reveal his code to a Samsung Galaxy Note. And the court said, distilled to its essence, the revealing of that passcode is a verbal communication of one's mind. It's protected under the 5th Amendment. And because he has to give an oral testimony of his mind, and then that information that's derived from it will be used against him as at trial, disclosure of the passcode is protected by the 5th Amendment. Now, that was certified at the Supreme Court along with another question based on the foregone conclusion doctrine, which I wouldn't get into here. But it is interesting to see how courts are handling disclosure of testimonial passcodes, and then also to consider down the line, now that so many people use biometrics to unlock their phones, how that's going to change in connection with face IDs or fingerprints or those things. And finally, State versus Warsham. It's a case where the fourth DCA analyzed electronic data recorders in automobiles. A vehicle was involved in a high-speed collision that killed the passenger. The vehicle was impounded. Without a warrant, police downloaded data from an event data recorder or a black box located inside the impounded vehicle. And the court analogized the data recorder to a cell phone, said that they document more than what's voluntarily conveyed to the public, and it's inherently different from the mechanical parts of the vehicle, and so was subject to protection. There was a dissent by Judge Forst. He noted that the data wasn't personal to the appellee, wasn't password protected by the appellee, was not being collected or maintained for the appellee, and probably the appellee wasn't actively aware that he was putting anything on there, and so wouldn't have found that data was protected. So that's just a preview of some of the issues the criminal courts are wrangling with as well. That concludes my presentation. I'm happy to answer any questions at the end, and I'll turn it over otherwise to Jim to give his presentation here.
Very good. Thank you, Peter. As Allison mentioned, I'm Jim Matulis. I'm going to be covering intellectual property, mostly trademarks, going back for about a year and a half in terms of coverage, because typically we have an IP symposium in April that got canceled due to COVID. So I'm going to go back a little bit more in time since we haven't really had an update on those. And it's going to be sort of a high level because there's been a lot of Supreme Court activity in that period of time. Let me screen share real quickly. Let's see. Yeah. And there we go. Okay, if you could let me know if that's visible. I'm going to assume it is. So like I said, we're going to be covering trademarks mostly today. The first case I'm going to talk about is Supreme Court case of Romig Fasteners versus Fossil. And the issue in that case is whether or not the finding of willfulness in terms of infringement under 1125A, unfair competition statute in the Lanham Act, is willfulness a prerequisite necessary every time in order to get infringers profits. And give you a little hint that it's not. Basically, the facts of this case are Romig is a company that makes these fasteners shown here on the left, and they had entered into an agreement with Fossil, who makes these purses on the right, to use the fasteners. Fossil was using them, everything went well, and then eventually Romig finds out that purse manufacturers, Chinese manufacturers, using counterfeit fasteners, and they wanted Fossil to do something about it. Apparently, they didn't act fast enough or successfully enough, because they ended up suing the purse manufacturer for violations of 1125A, unfair competition. Went to trial. The jury found that the defendant was liable, had a couple of specific findings, including that they had acted in callous disregard of the fastener company's rights, but they did not find that the infringement was willful. The court awarded the infringer's profits to the plaintiff, the fastener company. And the defendant argued that you can't do that because the court found that we were not willfully infringing. Under 1117, they argue there has to be a finding of willful infringement in order to get infringers' profits. The court took a look at section 1117, which basically it indicates that when a violation has been found of 1125A, and again, that's what the plaintiff was suing under, the plaintiff shall be entitled to, subject to the principles of equity, to recover the defendant's profits. And the defendant in that case argued that that, according to the case law that has been around for quite a while, there had to be a finding of willfulness. The court took a look at the statute and said, well, we don't really see that. First of all, we do see in 1117 that a violation of 1125A entitles the plaintiff to recover the defendant's profits. So that doesn't really say willful like the defendants were arguing. And more problematic was this very same section, there was a violation for which willfulness would trigger the right to recover the infringer's profits, and that's under 1125C. So the Supreme Court first started off saying this statute that you're pointing to, telling us we need willful, doesn't really support your argument. And then equally problematic was there's a number of provisions within the Lanham Act where the court was, or the Congress was capable of specifying a mental state. For For counterfeiting, it had to be intentional and with knowledge. For dilution, it had to be willful. All these various other provisions of this statute were capable of specifying a mental state. So the fact that we don't have one in 1117 sort of cuts against the defendant's argument. So the defendant went to the fallback position that the phrase "subject to the principles of equity" necessarily meant that the plaintiff had to show infringement to be willful in order to get defendant's profits. And the court took a look at essentially what "subject to the principles of equity" means. It wasn't exactly clear. They talked about how, a lot of times equity, even in the Lanham Act, identifies things like laches and acquiescence, things that are, equitable concepts. And they felt that it would just be too big of a leap to say that in every instance, there has to be a finding of willfulness based on that phrase, "subject to the principles of equity," to find that the plaintiff was entitled to the infringer's profits. So Supreme Court held that it's not a prereq to an award of infringer's profits, which is very, I think, earth-shattering in terms of what that means for folks that are found to be infringing without willfulness. Suddenly, a trademark case potentially means the recovery of all of your defendant's profits going back during the term of the infringement. And so that's quite a stick that plaintiffs now have that I guess in the past was a little less clear what had to be shown. Next case is USPTO versus Booking.com. And we all know who Booking.com is, travel-related website. They sought to get these 4 marks registered with the PTO, and the PTO rejected them. They said basically Booking.com in all of its forms that you're seeking to register is generic. And by way of background, or perhaps a refresher, a generic mark is a mark that defines the genus in which a particular product is a species. So for instance, wine would be generic because it describes the category of goods rather than the particular good that's being sold within that category. And the rule has always been that if it's generic, it cannot be registered. It cannot serve as a mark. Everybody should be allowed to use it to tell the customers what it is they sell. If, however, a mark is descriptive in that it describes a characteristic or quality of the product itself, then it's not immediately registrable, but it can be registrable with secondary meaning, meaning if the trademark owner has used it sufficiently that it now, when customers hear the word, they don't think so much of the primary meaning of the word, but instead they think of the trademark owner's company, then it has secondary meaning. And if you can show that, then you can have, in fact, registration and protectable rights. An example of a descriptive term would be speedy for, say, delivery services. So you use that, immediately you can't get it registered, but if eventually you promote it enough that customers now connect the word speedy with your company as the name, then you can get a registration. So the PTO's argument that was ultimately rejected is that booking is generic because it means, a process of creating reservations. .com is generic because it means a commercial website. So if you put them together, you're always going to have a generic combo. Generic .com individually and as a combination is always generic, and therefore any generic .com type application should be rejected. They're not entitled to protection. The Supreme Court disagreed, found that the more important question is whether or not consumers see a particular mark as generic, and if they do, then it's not registrable. But if they see it as a brand, then it is entitled to registration. And Booking.com was able to show a survey that it had performed in which 74.8% of the people responded that they identified Booking.com not as a generic or a genus of services, but instead as a particular brand. So as a result, taking into account what consumers think is the most important, they found Booking.com was not generic, and so those marks are now entitled to registration. The court made it clear that the PTO's per se rule that generic.com type trademarks can never be registered is not appropriate. The court needs, and the PTO needs to look at the applications on a case-by-case basis and take into account the customer's perception of them. And in the short time since that case has been filed, there's been a flood of new applications filed for generic.coms. And to the extent anybody has clients that have a company with a generic.com name that has recognition among customers, now it is protectable. So you should suggest they get it filed, get an application filed. Next case is Hard Candy, 11th Circuit case that assessed whether the issue of if a plaintiff files a trademark case or an unfair competition claim but doesn't seek their actual damages, are they entitled to a jury? And by way of background, trademark plaintiffs are entitled to various potential remedies, including actual damages, the defendant's profits, injunctive relief, DJ relief, things like that. The only one on this list is the first one that I've highlighted that entitles a plaintiff to a jury trial. The rest of these are equitable remedies, and if you're not seeking actual damages, then you do not have the right to a jury trial. Actual damages in the real world are a little bit problematic because they're not always easy to prove. Defendants are always able to say, well, your sales dropped not because of my infringement, but because of the market or because of some bad decision you made, your supply chain problems, something else. So they're always difficult to prove. But in the short term, before you get to trial, they're also problematic because they allow the defendants to do some fairly invasive discovery into the plaintiff's business, their sales, their revenues, their profits, potentially customers, things of that nature. So it's always a question whether you want to seek them anyway, because you do expose, the plaintiff exposes their own business to the defendant's inspection. And so because they do not, unless you're seeking actual damages, you don't get a jury trial. It's a good strategy decision to decide whether you want to seek them in the first place. Now, I think probably a practice pointer I would recommend is in your complaint, when you file it, if you're seeking, if you're suing for trademark infringement, go ahead and ask for actual damages. You can always drop it later. Once you find out if a judge is one that you think is going to rule for you, you can drop them. If you think the judge doesn't like your case and maybe you want to go to a trial, then perhaps you keep the actual damages and take it to a jury. But it's now clear in the 11th Circuit that without the actual damages, you're not going to be able to have a jury try your case. Next case is Tiffany. This is a Second Circuit case. Tiffany, as we all know, is Charles Tiffany founded it in the 1800s, became very famous. Along the way, he created a ring with a 6-pronged diamond setting, shown here in the corner. You can tell if there's 6 little prongs sticking out. And that became very well known. Often called the Tiffany setting or the Tiffany style, became essentially descriptive of the style of ring. In fact, they found that Costco, when they were sued for infringement because they sold a 6-prong ring, and they did so by just referencing it in some of the instances as Tiffany, Platinum Tiffany, if you can see there on the screen, Platinum Tiffany there. In some instances, their placards next to the products within the store only used the word Tiffany. Other placards used Tiffany said or Tiffany style. Plaintiff took umbrage to that and sued Costco not only for infringing for use of the word Tiffany, but also for counterfeiting. And the judge assigned to the case actually granted summary judgment to Tiffany's, which in my experience is very rare, short in the case of actual, stitch for stitch counterfeiting. Rarely have I seen cases granted summary judgment for the plaintiff. And in fact, not only did the judge grant summary judgment, he also entered an award of $21 million, 3.7 million in profits as found by the jury, but he took their opinion under advisement, decided that he agreed with it. So, in doing equity under the infringer's profits prong of the award, he agreed 3.7 was probably their profits, and he trebled it, which under the Lanham Act he's allowed to do. He added 1.8 million in Tiffany's actual damages and $8.25 million punitive damages found by the jury, and came up with a $21 million award. On appeal, the Second Circuit reversed. They found that there's issues of fact as to various of the several factors that courts consider when they assess whether there's an overall likelihood of consumer confusion. And so it's being remanded. The judge also found against Costco on its fair use defense. And that too was reversed by the Second Circuit. And it'll be interesting to see on remand how that plays out with a jury. On the fair use defense is probably the most important and interesting part of the case. The Second Circuit found that there was evidence that it was not used as a mark, which it has to be, you know, in order to avoid fair use. It was used descriptively, also a factor considered in fair use. And particularly interesting, I thought, was the fact that the court pointed to what Costco found over a century's worth of documents suggesting that Tiffany is widely used to understand a particular setting. And that was not only the case with Tiffany style or Tiffany setting, but even just the word Tiffany alone, they found, you know, dictionaries, they found trade journals. It was very commonly used in the industry to refer to the setting, not necessarily the company, Tiffany. So that case is going to go back on remand and retried. It'll be interesting to see. This is Second Circuit, which is different than 11th Circuit. So I don't know if they have the rule that the judge can decide everything except actual damages. But if they do, I would not be surprised if Tiffany drops their claim for actual damages, which got them 1.8 million out of their 21 million, knowing that they have a judge who views their case very favorably. And so perhaps they'll get just an award of 19 million. Those are the important trademark cases. To the extent anyone's not familiar, I wanted to make everyone aware that if they have clients who sell on Amazon, there are now protections in place for intellectual property rights violation. A couple of years ago, it used to be the case if you had a trademark product that you sold on Amazon, it was really hard to keep infringers off of it and counterfeiters as well. It was like a game of whack-a-mole. They'd constantly be popping up. You'd complain to Amazon. Amazon would take a few days to address it, agree with you, shut them down, and then they'd pop up under a different name. And so it was a really difficult process. Amazon has since launched their brand registry. So to the extent you have clients that sell products on Amazon and they want to prevent infringement, then what they need is a federal trademark registration. Once they get that, you can file it with Amazon, and then Amazon will do the job of enforcing, preventing others from selling on your clients' ASINs, as they're known. And so that's a really valuable right that to the extent you get the word mark registered, gives you a lot of value. Also, something else that recently rolled out is a new program called the IP Accelerator. And that is for clients that need a trademark. Typically, in my experience, it can take anywhere from 6 months to a couple of years to get the registration granted, depending on a number of things in the process. Amazon has now created this IP Accelerator program where they have gone out and vetted law firms that specialize in trademark registration. And they tout that if you work with the law firms, you'll be able to enjoy their Amazon protections that go with registration more quickly. Whether that's just a matter of having somebody prosecute your trademark appropriately and quickly, do it right the first time, or if they give the trademark lawyers a little more deference when they decide that a mark is probably likely to be registered. I don't know. I will plug Mike Chesel, whose firm Parrish, Chesel, and Herman is actually one of the firms that has been vetted. So congratulations to them. Next category is copyright. This one's been out for a little while, but it's one that's important to know if you have clients that are ever considering suing somebody for copyright infringement. Under 411A of the Copyright Act, the statute specifies that you have to have a registration before you can file a lawsuit for infringement. And for the longest time, there was a split of circuits in which some courts found that you had to have the registration before you could file. Other courts found that it was simply enough to file the application. And as long as that was pending, you had the right to come into court and sue for infringement. So the Supreme Court decided to split by finding that the Copyright Act says registration, and that means registration. So if you don't have one, you're not going to court. And that's, again, another process that under normal circumstances can easily take 6 months or more, even a year, just to get the registration. There is an expedited process that's quicker, but I understand, my experience is that the Copyright Office is pretty backed up. So if you have clients ever considering bringing copyright actions, they need to get that registration application filed. They need to get the registration, or else they won't be able to go to court. On the patent front, probably the most significant one, and I'm sort of staying away from patents to the most part because generally the BLS section probably doesn't get involved as much with those types of claims as patent or as a trademark and copyright. But a very significant case presently pending before the Supreme Court is Arthrex. And by way of background, if you have a patent and it's being infringed, you can go to court, and the defendants can defend in court, including defenses based on the patent being invalid. The defendant can also, if you've threatened them, go to the PTO. The PTO has an administrative process that's sort of like a trial. It's an inter partes process in which the two parties battle over whether the patent is invalid for certain specified reasons. And the important part of this is that the persons or the people deciding whether or not the patent are invalid are known as administrative patent judges. And you get a panel of 3 of them. And somebody filed suit. It was their patent was invalidated by one of these administrative patent judges, and they appealed, saying these judges are not their appointment violates the appointment clause of the U.S. Constitution. They're officers of the United States, and in order to be appropriately appointed, they have to be appointed by the president with the advice and consent of the Senate, and they were not. They were simply appointed by the Department of Commerce secretary, and therefore their appointment and everything they do violates the appointment clause. And the Federal Circuit agreed with that approach, saying, yes, you're right, they do violate the Constitution. And one of the things that is supposed to be done in that kind of context is to modify the statute to make it no longer violate the Constitution. And so that's what the Federal Circuit did. They basically removed the section of the statute that allowed APJs or administrative patent judges to be removed. They had certain protections in place, removal for cause. The Federal Circuit struck down that part of the statute. And so by doing so, there's no longer a violation of the appointments clause. And the Supreme Court has agreed to hear that. And depending on how that comes out, it could have a very significant impact. If the court were to find that the Federal Circuit is right, that they violated the Constitution, but that there's no saving it, then that could throw into upheaval all the decisions the APJs have made since the process was created in 2012. It could create just havoc for the system. I don't think that's going to happen. Excuse me. About low on time, so I'm going to skip over this Helsing case that basically stands for the proposition that secret sales do trigger the 1-year statute of limitations to get in and file your patent application. And the fact that the Patent Act was modified in 2012 doesn't really change that rule. So, the issue is if you're commercializing your invention and you wait more than 1 year to file, then you've waited too long and your patent should be rejected. I'm going to skip over that and to discuss one last thing before we go. And another Amazon administrative remedy for infringement, this time patent infringement. If you have a patent and you see that people on Amazon are infringing it, rather than having to go to court with them, there's now a procedure in place at Amazon where you can have a neutral evaluator decide whether or not there is infringement or not. Essentially, it's a fairly expedited process. It involves, first of all, filling out this form that's on Amazon's webpage that identifies the patent and the particular products. And once that's submitted, then they'll take a look at it. And by the way, this is submitted under penalty of perjury. So any patentee that wants to assert somebody's infringing their patent on the Amazon website does have penalty of perjury type risk of making false statements. If Amazon, they'll take a quick look at it and then send an agreement to both the seller and the patentee offering to participate in this neutral evaluation program. And if both sides agree, each side pays $4,000 to Amazon, and then there's an expedited process. It starts off with the patentee identifying first the patents that they believe are infringed, as well as the particular products and all of the sellers who are selling those products. up to 50 ASINs, as they're called, can be alleged to be infringed in one filing. Once both sides, either the sellers either agree to participate in the program, in which case it's litigated on an expedited basis, or if they choose not to participate, then Amazon will simply remove their listings, so they won't be selling the infringing product anymore. If they do decide to fight, then like I said, they both sides pay $4,000. Amazon selects a neutral evaluator, and then there's a schedule set that is pretty expedited, and from what I read, can't be changed. Basically, the patentee has 21 days to submit their arguments as to why there's infringement. Seller has 14 days to respond, and the plaintiff has another rebuttal period for 7 days. After that, the evaluator has 14 days to come to a decision as to whether there's infringement or not. If the seller wins, or if the evaluator finds that there's no infringement, then the evaluator is supposed to explain in writing why he believes there's no infringement. If he does find infringement, or she does find infringement, then they don't issue an opinion. They just simply say there is infringement, in which case the seller will be kicked off of selling those products on Amazon. The winner gets their $4,000 back. The loser loses the $4,000 that goes to the evaluator. If there's a bunch of losers, for instance, a bunch of sellers all fight it and they all lose, then the patentee, the winning patentee, gets to decide where the extra money goes to. Again, the evaluator only gets $4,000, Amazon gets nothing. But if there's 5 sellers fighting it and they all spent a total of $20,000, then 16,000 of those dollars will be dedicated to a charity of the patentee's choice. The patentee will get their own $4,000 back, and then the $4,000 that's left from the sellers that wasn't donated to charity is given to the evaluator. And there's no appeal process, there's no reconsideration process, but of course, after the process is over, then they can go to court and fight it out in a regular forum. That is all I have. I don't know if anybody has any questions or if we have any time, but thank you for your attention.
Thank you so much, Jim, and thank you, Peter, both of you, for your very thorough and very exciting presentations. As a member of the Business Litigation Committee, I tend to kind of go only to those committees usually because of scheduling issues, but I find, and I'm sure many of us can relate, there are lots of crossover issues. So, which is one of the reasons why I wanted to do the CLE and give exposure to all the different substantive areas to our members. And also a reminder, these CLEs can be used as study materials for the Business Litigation Board Certification exam, which will be next spring. I do not see any questions that are open at the moment. We will be posting these materials as well as a recording of these presentations to the website, our section website, flawbizlaw.org. So go ahead and log on there to view the part 1. In about a week, you can view part 2 on the website and our YouTube page. And as a reminder, we will be hosting part 3 with bankruptcy, UCC, and corporation securities and financial services presentations. That will be again at noon, and you can register on the website. The course number, for those of you who may have missed it at the beginning, is 4232, and it will also be designated there on the website. We do have one question, actually. Are there any best practices that either speaker recommends based on the recent decisions?
Not in addition to what I mentioned. To the extent there were some practice pointers or best practices, I covered them all.
Yeah, I think as well, I tried to point out some areas where I thought additional consideration was merited. I would just also say shepherdize these cases, because as technology changes, the law is subject to change too. So it's interesting to see where these things come out.
Great. So thank you both. With that concludes our part 2 of our case law update series. Thank you so much, everyone.
Thank you.